How to answer a civil lawsuit. Being served with a summons and complaint by a sheriff's deputy can be a frightening experience. Even if you had a general expectation that someone was planning to sue you, actually getting the papers can still be a shock. When you're served with a complaint, you have a limited time, usually less than a month, to get information together and file a response, or you may lose your case by default. Although specific procedures will vary among jurisdictions, the basic process to answer a civil lawsuit is generally the same. Evaluating your options. Read the complaint. When you are served, make sure you read the complaint carefully so you understand the allegations and why you are being sued. Write down any laws that are cited, as you will want to look them up so you understand what they cover. Check to make sure your name and address are correctly entered in the complaint. Make note of the deadline. You will have a deadline to respond to the complaint, typically 20 or 30 days from the date you are served. Keep in mind that this deadline typically is measured by calendar days, not just days the court is in session. So make sure you're counting weekends and holidays when you determine how long you have to respond. The deadline should be included on your summons, which also includes other information such as the date the hearing is scheduled. The summons also will include the plaintiff's information, so you know where to send a copy of your answer once it's filed. Keep in mind that this deadline typically is measured by calendar days, not just days the court is in session. So make sure you're counting weekends and holidays when you determine how long you have to respond. The deadline should be included on your summons, which also includes other information such as the date the hearing is scheduled. The summons also will include the plaintiff's information, so you know where to send a copy of your answer once it's filed. Contact the clerk of court. Before you begin drafting your answer, you may want to call the clerk's office and find out the court's basic procedures first. The clerk will be able to tell you what forms you must file, and when. For example, some jurisdictions require you to file a notice of appearance if you are representing yourself, before you file your answer. Gather information. Once you know what the lawsuit is about, related documents or other evidence you have in your possession can help you decide how you want to respond. For example, if you are being sued because you owe someone money, you might want to find any written contracts or agreements you have. Check the amounts stated in the complaint against the amounts on your statements and make sure they match. Look at each allegation in the complaint individually, and determine whether you have any documents or other evidence that either proves or disproves that allegation. Pull all those things together. Although you won't need them to file your answer, you will need them as the case progresses. Research the law. Check any law cited in the complaint as well as related laws to determine if you have any defenses available. Since you have a limited time to file your answer, you may not be able to do extensive research and legal analysis, but that's not really necessary at this stage. All you need is a basic understanding of why you're being sued and what law gives the plaintiff the right to sue you. You typically can find copies of your state's law online, on the websites for either your state court system or your state's legislature. You also may want to look on the websites of legal aid and legal self-help programs in your area, as they often have summaries and plain language descriptions of state law. Through your research, you also should uncover defenses you might be able to raise. If you so much as suspect that a defense might apply in your case, you'll want to go ahead and raise it in your answer. You'll have time to research it more thoroughly later. When you find the law that covers the plaintiff's claim, compare the allegations in the complaint to the elements in the law, and make sure they match exactly. If he or she has failed to include all the required elements, you may be able to file a motion to have the complaint dismissed. For example, if the lawsuit alleges you breached a contract, the plaintiff must allege that the two of you had a contract, that they fulfilled their side of the bargain, but that you failed to do all or part of what you were obligated to do under the contract, and they incurred damages as a result. If one of those elements is missing, the plaintiff has failed to state a claim. Consider consulting an attorney. If the lawsuit is complex or involves a significant amount of money, it may be in your best interests to work with an attorney. If you draft and file your answer without talking to an attorney, you could accidentally give up rights that you didn't intend to lose, such as the ability to raise certain defenses. Although an attorney can be expensive, consider that cost against the cost of losing the case. You may have an affirmative defense, which essentially means you did what the plaintiff alleges you did, but that you had a good reason or excuse for it. That excuse means you are not legally liable for the plaintiff's damages. Self-defense is one affirmative defense with which most people are familiar, and is used in both civil and criminal law. Affirmative defenses shift the burden of proof so that you, instead of the plaintiff, must show the court why you should not be held legally liable for the plaintiff's damages or losses. If you're thinking about raising such a defense, the advice of an attorney can be invaluable in assuring that you can prove all the required elements of the defense. Most attorneys will give you a free initial consultation, but keep in mind that they do have busy schedules. If you want to talk to an attorney before you file your answer, you should do so as soon as possible after you're served with the complaint. If you're worried about the cost of hiring an attorney, you might check with your local legal aid office or law school clinics and see if you qualify for free or reduced cost representation. Your local bar association also might have referral programs you can use. Some attorneys also offer unbundled services, in which they consult with you on some aspects of the case or assist in document preparation, but don't actually represent you in court. This sort of assistance can be more cost-effective and ensure that your rights are preserved.